You're listening to Legal Skinny Podcast with Trisha Barita. I'm a 15-year licensed practicing attorney in the state of Texas. I created Legal Skinny because when I've been invited to do educational seminars on different subjects in employment law, employers and HR professionals would often ask me, where can they find out a little more information on this or a little more information on that? Look, I get it. There's a lot of resources out there, but sometimes it's confusing and people are so busy. Sometimes people have only 30 or 15 or maybe even 5 minutes in their day to devote to learning something new. On this podcast, you'll hear me have discussions and interviews on topics relevant to employers. Disclaimer though, Legal Skinny is for entertainment and informational purposes only, not meant to provide legal advice and doesn't create an attorney-client relationship. Also remember, laws change or they differ by jurisdiction. So this is not a substitute for seeking legal counsel in your jurisdiction on the current law applicable to you. Welcome to the Legal Skinny podcast. Today we'll be doing the Legal Skinny case study, the state of New York versus the U.S. Department of Labor, continuing the discussion of that case with the topic being the Families First Coronavirus Response Act and the documentation requirement. So the state of New York challenged whether or not the U.S. Department of Labor exceeded its authority in creating regulations that stated, hey, employees need to provide some type of documentation to the employers prior to them being granted the leave. So this was quite controversial as far as how employers were trying to figure out, when do we give leave? What kind of documentation do we ask for? There were quite a few questions in the Q&As where the employers were asking the Department of Labor to sort of clarify, when can they ask for documentation? What should they require of the employees? And should they grant leave prior to or after getting the documentation? What if they can't get the documentation? Anyway, the Department of Labor addressed some of this stuff in the Q&A. Of course, they did address it more fully in the regulations. And the bottom line here is that the New York federal judge invalidated the regulation to the extent that documentation would be required to be submitted to the employer prior to leave. They found that to be unworkable in the situation, too stringent on the employees. They didn't agree with the blanket statement, and they found the whole thing inconsistent with the FFCRA statute to begin with. So, and the Department of Labor looked at this closely and determined, based on everything that they looked at, that they would go ahead and revise the regulations and the clarifications so that there was no confusion about this, therefore saying that notice and the documentation requirement need not to be given prior to, but rather may be given as soon as practicable. So employers that are looking at this issue and trying to figure out, okay, well, what does that mean for me? You should look at the issue of if someone is requesting leave, and if your policy is to require that they provide you documentation before you give them leave under the FFCRA, rethink that now based on the changes that the DOL has stated. They've always mentioned in the Q&A that they wanted the employers to be flexible, but now they've actually made some changes to the regulations. So, I would see it as a cautionary tale to employers to be denying leave, based on just the pure issue of an employee not having the right documentation. And that's kind of, I think, the intent of where the DOL was intending to go and where the New York federal judge wanted the Department of Labor to go with the revision in this regulation. So with that is the Legal Skinny case study on the FFCRA documentation requirement in the case, the state of New York versus the U.S. Department of Labor. Thanks for joining us on this episode of the Legal Skinny podcast. Do not forget to subscribe to get future podcast episodes. Also, check out LegalSkinny.com to join our newsletter and get details on all the educational resources we offer the employer. Also, disclaimer, remember Legal Skinny is for entertainment and informational purposes only, not meant to provide legal advice and does not create an attorney-client relationship. Laws change or they differ by jurisdiction. So also remember, This is not a substitute for seeking legal counsel in your jurisdiction on the current law applicable to you.